Okay, this week our mini series on the estate planning process is going to focus on divorce and how divorce intersects and interacts with estate planning. As estate planners, we see divorce from a variety of angles on a weekly basis in our practice. And that could be helping a newly single individual after the divorce decree has been ordered by the court establish this new life and implement a new estate plan that's going to better adhere to their wishes. Or it could be helping a parent or grandparent plan for the future generations in their trust agreement or in their estate plan as a hedge against the risk of divorce for a loved one. So divorce is something that's not fun to talk about, but it impacts the law in a variety of ways. And it is really impactful when we're talking about estate planning. And so that's why we have selected the topic this week. The last thing that we want to happen to our clients, they've come through, they've got their divorce decree, they're newly single, they have full control over their assets and their estate and their financial affairs, is for their estate to be conveyed and distributed in a way that does not align with their wishes, okay? So our blog is going to dive a little bit deeper into some of these topics, but one of the things that we want to speak on today is in the divorce decree, which is the final order from the divorce process, is how does that impact the estate plan? Well, support obligations are one of the topics that is going to be outlined in that decree, and that could be child support obligations or alimony or spousal support. And sometimes it may require or necessitate the purchase of a life insurance policy to govern those obligations, to ensure those obligations are fulfilled in the event of death. And it might be prudent to establish a trust to actually own the policy and make those payouts to the minor child as opposed to the ex-spouse inheriting or receiving those assets outright, which he or she may or may not use wisely or prudently. When we're talking about property division, especially marital property that had previously been owned jointly as tenants by the entirety, it's likely now owned as tenants in common. And so a will can effectively and usefully convey the interest in the real estate that has now been newly acquired and conveyed to the new beneficiaries in the will or trust agreement. And so estate planning needs to be updated after a divorce decree has been implemented to govern the remainder of the estate, as it has very likely been altered after that divorce has been finalized. But we're getting questions a lot about how a divorce decree actually impacts an existing estate plan. That's a very good question, and there's a variety of assets in the estate. Estate planning is holistic. And when we're talking about a will in Tennessee, every state is very different as it pertains to property law, but in Tennessee, an ex-spouse would not inherit so long as that will was executed before the divorce decree. That doesn't mean that you don't or should not update your estate plan because courts are going to analyze the remainder of the will, and that is likely not to actually sufficiently carry out the individual's wishes. So wills need to be updated and revised, and if you don't have a will, it would be a great time as you establish this newly single life. Trust agreements, the laws around trust and amending a trust, they vary, and that's why it's important that you meet with an estate planner after a divorce. If there is a prenuptial agreement, a postnuptial agreement, that could impact the ability and the flexibility to estate plan after the divorce. Again, the divorce decree itself may govern how some of the planning can be done, and that's why it's important that you bring that decree in as you implement a new estate plan. But and there may have been some joint planning done in that trust agreement, and it's important that it has been reviewed and the desired changes are made. So there may need to be an amendment. There may need to be a new trust agreement implemented altogether. Life insurance. This is something that is very critical. Beneficiaries need to be updated. An ex-spouse can certainly receive benefits from the policy under Tennessee law. The law views life insurance policies as a separate contract that was done outside of the marital estate, and so it's vital that we update not only beneficiaries on life insurance policies, but retirement accounts, as they are regulated under the ERISA Act and they are federally regulated. So again, give us a call. You're embarking on this new life. Although it's been emotional, it's not fun to go through. Most of our families at some point or another have been impacted by divorce. It's important, while there's been enough time and money probably spent on divorce litigation, it's important that the estate planning is done properly on the back end of a divorce. So if this is something that your family's dealing with, please give us a call. We'd love to help. On another note, we've got a couple workshops coming up this month. They've been growing great. It's one of our greatest honors to get this knowledge out to the community. It's part of our mission statement as we serve the greater Middle Tennessee region. We've got a workshop coming up later this month on long-term care planning and Medicaid planning. We've also got some lunch and learns. All of these events you can register on our website. Those lunch and learns are going to be free. We're working with a variety of advisors throughout the plateau in Middle Tennessee to work in a collaborative environment to bring this knowledge to you. Come in, please take it, put it in your toolbox. It may be something that you can use down the road. Again, follow along, click the link below to read the full blog this week, and we look forward to bringing our next topic next week.